Welcome to this information session at the Law Society, complaints handling with regards to complaints and the LSRA. I'm joined today by Eamon Maguire, who's Regulation Complaints Manager with the Law Society. In this role, Eamon has been responsible for winding up the Society's Complaints and Client Regulation section, which commenced in October 2019, when the LSRA assumed responsibility for complaints handling. Eamon guides the profession on a range of subjects, from effective complaints handling to the solicitor's advertising regulations. Eamon is Secretary to the Complaints and Clients Relations Committee and has recently stepped into the role of Secretary of the Guidance and Ethics Committee. So you're very welcome, Eamon, and everybody on the call today. Over to you, Eamon.
Thank you, Justin. Thank you to Member Services for asking me to come and speak. The Regulation Department is always very keen to do whatever it can to assist and support solicitors when they're attempting to comply with any aspect of regulation. And so to have this opportunity to discuss just the best approach for effective complaints handling is really helpful. So thank you. As Justin said, my name is Eamon Maguire and I'm currently the Complaints and Regulation Compliance Manager in the Law Society. And over the last couple of years, I've been focused on winding up the Complaints and Client Relations section, which closed formally in October 2019, whenever the LSRA, or the authority, as I will call it throughout this talk, assumed responsibility for complaints handling. And so before I wanted to actually get into what a solicitor should do when they receive a complaint and the types of supports that are available, I thought it would just be helpful to contextualize the complaint handling process, first of all, by just grounding it in the approach that the authority takes, and then we can just work from there. So if you are following by the screen, there's I have a short PowerPoint presentation, but if you're not accessing it by a device that you can view this on, don't worry, because it's all covered in what I'm saying as well. So maybe just to add, we have we'll send a recording out at the end of the week with the slides, and then we have a leaflet available with hyperlinks in it to all of the resources that you might need. Okay, that's brilliant. Yeah, and there is also the accompanying leaflet, which will have all of the supports listed in it that Justin and Member Services have put together, so you'll have that too. But just to start by giving an outline of what the talk's going to cover, I'm going to be looking at the types of complaints that can be investigated by the authority, what exactly the admissibility stage is, because I know that that can cause a lot of confusion for practitioners. I'll then move on to the investigation process generally, just to discuss what it involves, what it looks like, what you can expect. I'm then going to look at the complaints committee, just describing what it does, what its function is, how it's set up, etc., before then looking at the review committee and where in the investigation process that also fits and how that would be useful, particularly if the complaints committee has made a determination that you're not happy with. You can refer the matter to the review committee. And then I'm just going to wrap up by looking at what exactly it is you would need to do and how best to approach an investigation, and then what support tools are available to you in order to successfully navigate this process. So, I mean, I don't think that this is going to come as a surprise to anybody on this call today, but the types of complaints that the LSRA or the authority can investigate are the same as those that the society would have investigated, with the three main categories being: 1, inadequate professional services; 2, overcharging; and then 3, misconduct. It's a bit obvious to say that Section 51 of the LSRA Act 2015 states that the first 2 categories of complaint are types that can only be made by clients of solicitors as they relate to the services provided by the solicitor. And in terms of time limits, there's normally a 3-year time limit on those types of complaints, either from the completion of the work or the point of knowledge. So if, say, you, I don't know, instructed a solicitor to carry out a property conveyance, and you then went to sell the property 10 years later, only to discover that you weren't actually registered, well, then you could make a complaint at that point. And so the 3-year time limit would start ticking at the point of knowledge around that. The third category, however, this is the one part where I suppose the society previously had a pretty effective screening net for complaints that has been lifted by the authority, and where basically previously only clients of solicitors could make complaints of misconduct. that was how the society approached it. And if, say, an individual wanted to make a complaint about any solicitor on any topic, they could, but they would need to have that complaint endorsed by their own solicitor. And that was a really good filtration system, I suppose, for just sorting out the wheat from the chaff. That doesn't exist with the LSRA and under the LSRA Act. And under section 51(2) of the Act, misconduct has now been opened up to, quote, any person, which means anybody can make a complaint without any time limit. And just to expand that even more, the definition of misconduct now also includes the complaint of bringing the profession into disrepute. So again, like the notion of bringing the profession into disrepute is very broad, and this is a continued sense of frustration for solicitors insofar as they can such a broad complaint category can invite many unmeritorious complaints against a solicitor, which the authority is then bound to consider and then put to the solicitor before determining its admissibility. So like what you can hopefully establish from just that very early introduction is the importance of full and early engagement with the authority, because as much as a complaint in your mind might be completely without merit, the authority is bound to consider it and at admissibility stage put it to the solicitor. And so if you're able to just from the jump explain what was involved, what work was required, what you'd done, what fee structures were quoted, etc., etc. If you can set it all out, then it could clearly demonstrate to the authority that it's either a frivolous or vexatious complaint, and it'll ensure that the investigation doesn't pass admissibility stage.
So, Eamon, a quick question there. Is there any way a bogus complaint can be penalised?
Penalised against?
The complainant.
No.
So if they're making vexatious complaints that haven't been upheld?
No, unfortunately not. It just wouldn't pass admissibility stage. And also, and I know that there was a complaint or a question that came in last week about whether solicitors can make complaints about their colleagues. The answer is yes, and it would fall under the complaint of misconduct and just that broad definition of bringing the profession into disrepute. And then it's up to the solicitor just to include as much information as possible to have it dismissed at the admissibility stage. So in terms of the admissibility stage, I wanted to start by saying, first of all, that often solicitors can make their case before a complaint is even formally received by the authority. And so if, say, you're dealing with a difficult client and they then start threatening the authority, what you can do then is just cut it off at the pass and say, look, I'm dealing with this client, this is the work that I was instructed to do, this is what's happened, etc. And the threat of a complaint is being made, so I just want to preempt that. The authority actively encourages this because, as I said at the very beginning, there are many complaints which don't pass admissibility stage. And just for anybody who didn't hear me, quote the stats from the LSRA's annual report. In the second half of last year, 994 queries were received by the authority and 216 didn't proceed. And so that'll tell you that if you give as full an answer as possible, or even preempt a complaint being made, it can just get rid of it from the very beginning. So admissible means that having sought the views of the solicitor and conducted the preliminary review of all the information available, the authority is satisfied that there are matters which require resolution and or investigation. The decision regarding admissibility rests with the authority. It's for the authority and not the parties to the complaint to decide what is and isn't admissible. Just anecdotally, it's emerged over the last few years that this stage can be a bit hit and miss for the, or in the view of the authority in terms of how solicitors engage and respond. So sometimes and very often solicitors provide full and frank responses or submit their statement in anticipation of a complaint being made, as I said. And the information in the documentation is sufficient to clearly demonstrate that the complaint doesn't meet the admissibility threshold. Although the initial time spent on all of this might seem wasteful, particularly if you're running a busy practice or if you're a sole practitioner in particular, And also, I suppose, if you feel that there's no grounds for the complaint whatsoever, it can be very frustrating to actually have to then waste more time answering this. It is important, though, to say that it's in everybody's interest to tackle it head on, because not only does it add professional clarity to the investigation and allows for resolution without ongoing engagement, but it can also ensure that everybody is engaged and that the complaint process keeps momentum too. The LSRA, the authority's primary function is to seek to resolve complaints by resolution. And if a solicitor isn't engaging, it can't be resolved. I think it's also important to point out at this stage too that, that the admissibility stage isn't about forming some sort of a moral judgment on the complaint or getting into, you know, how difficult the client was or how problematic they were, etc. You just need to stick to the facts. Okay. So once then, let's just say that the a complaint has been made. It's been put to you to assess its admissibility. The authority believes that there is a complaint there to answer. What next then? So after that, after the complaint's been made, there are a couple of avenues that the complaint may take. Under the 2015 legislation, complaints relating to inadequate professional services and excessive costs are both automatically selected for the authority's informal resolution process. And again, this is a new thing that has been pioneered by the authority. And really that's just to allow the parties to seek to resolve the matter in an informal way using the facilitators in the authority if they choose to. That might either make the process less stressful, more expeditious, etc. The LSRA strongly recommends that solicitors engage in this informal resolution process as fully as possible because, as I say, it can just short circuit the investigation. Complaints which are considered by the authority to fit the criteria for misconduct, however, they go straight to the complaints committee for investigation. So the executives in the LSRA don't have the authority to make any determinations on misconduct complaints. They would just go directly to the complaints committee. So although no two complaints are the same, early engagement on the part of the solicitor elicits a much favourable outcome for all parties. It's also important to say, and I mean, if I am being very repetitive in what I'm saying, I hope that the one thing you do take away is that early engagement, communication, responding, all of that is the most important thing. And very often, many enforcement proceedings that are pursued by the authority in the High Court currently often relate to non-engagement. So you will save yourself a whole world of trouble if you respond in a timely way, because if you don't, the response will be forced from you all the way up to the High Court and the High Court order enforcing you or forcing you to respond. Poor communication lies at the heart of the most challenging complaints. And I mean, this again is not going to come as news to anybody on this call, but whether the original complaint started with the solicitor or with the solicitor not informing the client in the first place, to the solicitors then resisting the admissibility stage, or then resisting the informal resolution process or the determination stage, all of it comes down to communications. Excuse me. So as I said, though, separately, complaints of misconduct are formally investigated by the Complaints Committee. And if it looks like the informal or the information resolution process has reached an end without success, the authority will notify the parties that it intends to make a determination on the matter with a 30-day period given. So if you decide to engage in the informal resolution process and it concludes without success, you'll be notified of that and given 30 days then to provide any further submissions. So if it gets to that stage, if your complaint relates to inadequate professional service or excessive costs, and the authority is going to make a determination, Section 61 is the section of the LSRA Act that sets out all of the various findings that can be made against you or directions that can be issued to you. And they include you rectifying the matter at your own expense, taken further action as directed by the authority for up to €3,000, to transfer any documents relating to the complaint to another legal practitioner nominated by the client. So this is obviously to allow the client to continue with whatever case they have. And then also to pay compensation of up to €3,000. So that relates to inadequate professional service complaints. If directions are given by the authority in terms of excessive costs, however, I mean, this is kind of obvious, but the directions would either be a refund without delay, either wholly or in part as directed, or to waive, whether wholly or in part as directed, the right to recover any costs that are owed. So now that we've gone through the admissibility stage, the informal resolution process, and assuming that your complaint relates to either inadequate professional services or overcharging, and the informal resolution process wasn't successful, it may then be referred to the Complaints Committee. The Complaints Committee will look at IPS and overcharging complaints in some instances where the authority hasn't been able to resolve the matter, or it will always consider misconduct complaints. And as it says on the slide, not only does it look at alleged misconduct, but it's also important to know that the Complaints Committee is independent in its decision making. So if a complaint was made against you regarding misconduct, it passes the admissibility stage, it goes automatically to the Complaints Committee, and they are responsible for the management of that investigation. Once the complaint of alleged misconduct passes the admissibility stage in the normal way, then, as I say, it'll just go to the Complaints Committee for adjudication. This committee will sit in various divisions, which comprises of 3 or 5 members, and always has a lay majority and a lay chairperson. And for matters relating to solicitors, there will be a solicitor member on the committee too, and they meet on a rolling basis approximately every 6 weeks. So it's quite pacey, and as I say, they'll be the one communicating with you, the committee itself. The committee can request complainants or solicitors to supply information or documentation relating to a complaint, and they can also require either party to verify information by way of an affidavit. The committee can also require complainants and solicitors to appear before it for the purposes of the investigation of the complaint. As I said previously, the solicitor is required to comply with any notice issued to them to submit information. So just do it, just give the information that's being requested. It's also worth noting that under section 59(1), the authority can request the Law Society to carry out its own investigation under the Solicitors Act. So if, say, a complaint has been made about misconduct and the misconduct relates to a breach of the Solicitors Act, then the LSRA can ask the authority or the society to investigate that complaint. The Complaints Committee as well, and this is probably the most, not important, but certainly the more serious part of the work that they do, they can refer matters that they consider sufficiently serious to the Legal Practitioners Disciplinary Tribunal for further investigation. So that's where the misconduct matters end up. Under section 71, if the Complaints Committee considers that misconduct occurred, but that the complaint didn't warrant a referral to the LPDT, however, there are various directions that it can make. And it can be to either direct the solicitor to complete the work free of charge, to waive fees, to direct compliance with an undertaking that was given, to pay the solicitor, or for the solicitor to pay compensation not exceeding £5,000, to direct costs to the society's investigation. And then also with the consent of the solicitor, it can impose a specified restriction or condition on the practicing certificate or the practice of the solicitor. So that's with the solicitor's consent. If the solicitor does not consent to that, however, then the matter will proceed to the Legal Practitioners Disciplinary Tribunal. But for the solicitor, however, that isn't the end of the road. So if, say, a finding of misconduct has been made against the solicitor, but it wasn't a breach that was sufficiently serious to justify a referral to the LPD, and the solicitor isn't happy with that. So just say, for instance, you've been slapped with, I don't know, £5,000 compensation. You have to pay 5K to the complainant and you're not happy with that. It's not the end of the road. If you're dissatisfied with the determination made relating to a complaint, what you can do is request a review of the decision, and this is important. It must be made within 30 days of the determination. So if you're not happy with the determination made by the Complaints Committee, you have 30 days to refer it to the Review Committee. Any direction made by the authority is then suspended for as long as a request to review the determination has been made. So if, say, as part of the determination, you have been directed to do something, you won't have to do that something until the Review Committee has properly reviewed the determination that was made. So what is the Review Committee? Similar to the Complaints Committee, it's made up with 3 people also, 2 lay people and a solicitor. And they review all of the documentation available to it, excluding all previous attempts to resolve informally. And again, I think that's important to note that if, say, you decide to engage in the informal resolution process and it doesn't work out, there's no adverse impact of that on you at a later point. So if, say, it breaks down at the informal stage and then the Complaints Committee makes a determination that you're not happy with, you can still refer the matter to the Review Committee, and they will assess all of the information that they have, but not included in that assessment will be any previous attempts made to resolve it. They will then make this is the Review Committee, will make one of 3 decisions. So there's 3 possible outcomes. They will either confirm the determination of the authority, send the complaint back to the authority to be dealt with again, or issue one or more direction to the solicitor. So then what happens when the Review Committee has made its determination? Again, it's not the end of the road. And if you continue to be dissatisfied with the outcome at the Review Committee, if, say, it upheld the original determination or made another one that you were dissatisfied with, you have a further 21 days to apply to the High Court for an order directing the Review Committee to rescind or vary the determination as the court thinks appropriate. And if you wish to refer the matter for review, again, don't delay in doing this and I was speaking to the head of the complaint section in the LSRA last week, and he was saying that very often solicitors are simply out of time, and there's nothing that the authority can do about that, and there's nothing that they can do about it, and they're then bound by it. It becomes binding after 21 days. So where the Complaints Committee then separately makes a referral to the LPDT, this is in matters of misconduct, they can do that if they can see on the face of it that the issues that are raised are sufficiently serious to justify a referral. Because of this, and because of the very serious allegations that are made and considered by the Complaints Committee, it's really important, and I don't care if I sound like a broken record at this stage, it's really important that you engage enthusiastically with the investigation process at every stage. In particular, always respond to a notice to verify information. You may represent yourself or be represented by a person of your choice, and the cost of such representation is with the solicitor. I do think, however, as Secretary to the Complaints and Client Relations Committee, I would, depending obviously on a person's means and what it is that they want to do and how they want to manage the process themselves, I do think that, say, solicitors who are represented, the arguments that are made on their behalf are often much more coherent and are received better by, this is the Complaints and Client Relations Committee, so I can't say about the LSRA's committee, but I imagine that the same would be true. So just maybe keep that in mind, that those who are represented, it serves their interests better. For serious allegations which don't involve criminality, however, the Legal Practitioners Disciplinary Tribunal is the one that considers that, but any allegations of a criminal nature made against the solicitor would be referred to An Garda Síochána. In terms of the tribunal, then, it has a wide range of sanctions available to it, and they're all under Section 85(7). But if I can just list off some of the bigger ones and the more potent ones. So a sanction could involve advice given to you, an admonishment, censure, restrictions placed on your ability to practice. You could be suspended from practice. You'd be asked to pay a sum in restitution, or the ultimate sanction, which is to be struck off the roll. So again, it's really important that you treat this process with the seriousness that it deserves. And if, say, the legal practitioner's disciplinary tribunal makes a determination that you're not happy with, you have 28 days to appeal that determination to the High Court. So now that I've gone into all of that, I'll just go through what you should do in terms of how to approach the complaint investigation process. These points, which are on my screen now, are also set out in the really helpful information leaflet that Justin had put together that accompanies the materials. But just to go through them.
Sorry, just to say one thing, Eamon, can you allow some time for questions at the end? Because we've quite a few that have come in there.
Yeah, absolutely. Okay. So in terms of, just conscious of the time, well, what you should do, as I've said repeatedly throughout this, engage as early and as comprehensively as possible. Always read and digest the information in any letter or correspondence that you're given. Review the disciplinary or complaints policy related to claims being made. So if the complaint is IPS or overcharging or misconduct, look at the relevant section under the Act and make sure that you're secure in the allegations that are being made and that it actually meets that criteria. Check all of the details of the complaint being made. Think back to the event and research any relevant files. Prepare a response. In preparing a response, I would say that it's important, and I'll come to this now in terms of the supports, speak to people around you, whether it's a colleague in your office or a colleague in a different practice, or if you're not able to speak to those, maybe a friend. Bouncing ideas off other people and thinking out loud is a really effective way to prepare a detailed response and to trigger your memory as well of key events. Respond to any letter in a considered fashion and attend any disciplinary meeting with counsel or a support person. As I obviously previously said, those who are represented often far better. But what I'll also say is, if you do decide to instruct counsel, try to avoid giving last minute instructions, asking for an adjournment or whatever, because that can be a source of irritation for the LSRA, and it frustrates like the momentum that they try to maintain with their investigation. Okay, finally then, and yeah, I think we have time for questions then. So in terms of supports available, so the LSRA has a really helpful the section of their website which sets out detailed guidance on how to respond to a complaint, and it also provides loads of info on all of the various stages of the process. If you are on the LSRA website, try and find the Complaints Information Guide, because that's a really handy, digestible document that sets out everything you need to know and everything that I've already covered. In terms of what the Law Society can then do to support you, in the first instance, the Society's Guidance and Ethics Committee, it's first of all a treasure trove of published guidance and practice notes, and it covers a huge range of topics, from the transfer of files to legal costs, to also having a guidance and support helpline. I've just recently stepped into the role as secretary to the Guidance and Ethics Committee, and I attended my first meeting 2 weeks ago. But I can see that the accompanying leaflet that Justin has provided you with has the number for the Guidance and Ethics Helpline, and that's made up of exclusively solicitor members willing to support colleagues in regulatory difficulty. There's also a guide to access the Guide to Good Professional Conduct from the Law Society website, so there's plenty of support there if you want to just reach out and knock ideas off anybody. There's then 29 bar associations up and down the country who are willing to assist colleagues experiencing difficulty, plus the Dublin Solicitors, the DSBA, the Dublin Solicitors Bar Association, offers a consult a colleague service, which is something that is entirely confidential, free of charge, and nationwide. So again, that number is included, and it can be really helpful if you just have been bamboozled by this complaint and you need to talk it through with somebody. If the idea of speaking to a colleague in the Guidance and Ethics Committee or in reaching out to a various bar association is a bit too daunting for you, you're free to reach out and speak to me directly. As I said before, very often the best approach can be teased out over a conversation. And if there's any specific technical queries, you can always email me directly. But I often find that when speaking to solicitors who are engaged in this process, they answer their own questions a lot of the time because they know what they need to do, but they just need to say it out loud and get their head straight around it. The Solicitors Benevolent Association also seeks to assist solicitors and their dependents. The Society maintains a panel of solicitors willing to help colleagues in regulatory difficulty. And then finally, and on a more personal level, if you're engaged in a regulatory process that's having a serious detrimental impact on either your physical or your mental health, the Society has a range of psychological supports available. And this includes Legal Mind, which many of you may already know about, but it's a service of trained counsellors who you can speak to confidentially. And again, further information is contained in that accompanying leaflet, but do reach out to the Psychological Services section of the Society if you think that that could be something you would benefit from. So then just in terms of wrapping up, I'm just going to quickly rattle through.
Could I cut you off there, Eamon, for a second and just get you to take a few questions?
Sure.
Coming up the chat. Can you see the chat there? I mean, some of them you may have covered. So the first one there was, I was on the Guidance and Ethics webpage and I couldn't see the practice directions. Okay, well, we'll send them on to you then.
Okay.
Sorry, it's just the chat there. Complaints against doctors and most other professionals have a minor poor professional performance and a more serious professional misconduct complaint stream. Why does the LSRA handle a minor breach of solicitors' ethics rules the same as fraud, dishonesty? I'm not sure we can answer that question really, because
we can't, but also it's because of the definition of misconduct has been extended and made so broad. It again comes back to early engagement and just knocking out anything that you think is spurious, vexatious. There's nothing we can do about that, I'm afraid.
Okay, another query then was, what is the standard proof applied by the LSRA in assessing determining complaints? Presumably complaints must be made out of beyond or all reasonable doubt, since the consequences result in a penalisation. But what is the standard of proof?
I will confirm that.
Yes, okay.
It's the criminal. It was previously the criminal standard,
and I'm sure it's on the LSRA website.
Yeah.
Have there been many complaints concerning social media communications via firms' channels? The tweets of a defense lawyer in America. Okay, has social media come up as a major issue?
Yes, and actually, even more topically, like the Gary Lineker type complaints around tweeting, etc., are ones that are made, but they're the ones that are dismissed and don't even pass admissibility stage.
I assume that if a complaint is upheld by LSRA, that a solicitor can challenge it under judicial review.
That's also an option, yeah.
I have one that was not admitted, but has gone all the way to the High Court on €180. I mean, it's hard to comment on that, but can a complaint bring something to the High Court? Well, obviously they have, but
yeah, I would have thought that the amount involved is far too low. But I'm not sure what that has to do with the LSRAs.
How long does the admissible stage take if no queries are raised? How long does the process take?
It can be very quick. If so, it depends. I mean, it depends on who is saying what and what is being said. So the solicitor can sometimes send their entire client file. And I mean, that'll take longer to get through than, a 1 page of bullet points.
If you preempt and disclose, given GDPR, would you have to do it on an anonymized basis? That's in case the client's not followed through with the threat to complain.
That's a really good question. I can find that out. That up. GDPR regulations.
I would like to know the statistics for what percentage of third-party non-client misconduct complaints pass the admissibility threshold. Is that what you referred to earlier?
Yeah, it didn't. The LSRA's annual report didn't get into such granular detail around the misconduct complaints. They just gave the top line percentages.
People are talking about vexatious or frivolous complaints from one solicitor to another or by another. I mean, it's probably hard for you to comment on that because you don't have enough detail. a solicitor take defamation proceedings against a complainant, the complaint is found to be totally without merit and simply to blacken a solicitor?
Well, I mean, it could be considered, absolutely, but it's separate from the complaints process. It'd be a completely separate legal action.
I had a case where there were no solicitor client fees changed, but the complainant has made a complaint about fees when none has been charged to him. What is the best approach to get the complaint dismissed?
To say that, I mean, to say that very clearly.
Yes. Okay, so bring that to the attention of the LSRA.
Exactly.
If you get a complaint by the LSRA, must you advise your insurer, do you think?
That's a good one. I will double check whether, as far as I know, you don't need to declare complaints that have been made, but I'll check and see whether, when it comes to complaints that are upheld, that's a different thing.
What is the time limit on the part of the LSRA to confirm whether or not a claim is admissible, and if deemed admissible, the time limit for determination? I assume no statutory time limit, but what is the average timeline, do you think?
Yeah, they're reluctant to give time limits because they've been having problems with resources and staff. But I know that has been addressed and their time periods have closed. So I think you're probably talking 8 weeks.
Okay, here's doctors differ, patients die, but solicitors differ. I don't know what happens, but I think admissible, somebody's saying I think admissible complaints should be notified to insurance from one person. And then the second person is saying, I'm pretty sure you only need to advise insurers if a finding is made against you per the common proposal form.
What I'll do
so we're going to clarify that.
Exactly. I can clarify that with the secretary of the PII committee, because I don't want to give any answer that isn't definitive.
Yeah. So here's one from Bill. I hope you're getting well, and it's good to hear from you. But Bill Holohan, who is chair of the PII committee, says you only need to notify insurers if there's an allegation of a claim and you intend to claim indemnity.
There we go.
There we go. So you only need to notify your insurer if there is an allegation of a claim and you intend to claim indemnity.
There we go.
So we're coming up to the end there. If you want to just wrap up, I know we've gone a little over time, but I know this is a very sensitive, and people are really anxious to find out more about this LSRA and complaints. So if you want to wrap up there, Eamon, and give some final thoughts, thank you very much for your time today, and thanks everyone for joining us.
No problem, and apologies for running over.
No problem.
Yeah, I just want to repeat that the most important thing to do is to engage. When the complaint has been made, however spurious you might consider it, take the time to respond fully to all allegations so that you think that it might not pass the admissibility stage. Discuss things with colleagues, with the society, with all the various supports that I suggested. Stay focused on resolution. Difficult complainants show themselves throughout the investigation process. So stick to the facts and resolving matters. This is what all parties want, and the quicker the better. And then finally, if you're unhappy with the determination period, make sure you seek a review or appeal within the appropriate time period.
Well, thank you very much. I know everyone is anxious to get their hands on this leaflet. We'll be sending it out with the recording on Friday. We just have just a final minor edits to the links on it. So thanks everyone for joining us today. Special shout out to Eamon for putting this together. So it's quite a detailed area, and we really appreciate your time. If you have queries for Eamon, they can contact you via your details are on the slide, are they, or they can come to me directly?
Yeah, e.mcguire@lawsociety.ie. So feel free to, if you have, please do. In fact, if you have any follow-up questions, email them to me, and then I can research them and make sure I'm giving you the right information back.
There's a query there from, can you answer my question, from Hillary? Hillary, do we have your question? Is the question. Very informative. I'll just do a quick, whether I can find the question in the, maybe we'll just take you offline, Hillary, and we'll come back to you during the afternoon. Can you see a query there from Hillary? I don't seem to be able to see it. No, it's not coming through on us. So I'm afraid we're out of time. Hillary, we'll come back to you directly, or you can send Eamon an email specifically. Thanks everyone for joining us today. Hopefully you'll join us in 2 weeks' time. We're looking at Law Society, or not Law Society. Evelyn Partners are going to be talking to us about some research they've done on the Irish legal market. So we'll talk to you then. Thanks everyone. Slán agus go market.